Brian?
Yes.
Okay, just making sure. Okay, I'm gonna share my screen and we'll get started. The center. And we'll get started. I'm hearing an echo. Let me see if I can get off of YouTube. The center. It's okay, baby. All right, let me try it again. Okay, can you see this, Brian?
Yes.
Okay, all right, we'll go ahead and get started. Don't give mommy a hard time, please. Okay, so welcome. Thank you for joining us today. Today we're going to be discussing brand identity and ownership and why it really matters to you as a business owner. Why should you care about these things? Okay, about the company, if you don't know about us already, we are a business and civil rights law firm here in Atlanta, Georgia. On the business side, we assist Black and Brown entrepreneurs with building legally sustainable empires by empowering them with effective legal strategies and Okay, so what is intellectual property? So since you're the only person here right now, Brian, you have to answer all the questions. Are you able to talk or no?
Yes and no.
Yes and no. Okay. All right. Well, I'll just ask you the first one then. What is intellectual property in your own words?
I guess it's your ideas, the whatever it is that you're trying to do, whether it's a process, a system, or product. I guess it's your property if it's something that was created by you.
Yes, that's a good definition. I like to think of it as our brain power. So, you know, physical property are things that we can touch. Intellectual property, we can't touch it, right? But usually our intellectual property is going to be more expensive or worth more than our physical property, because physical property can be replaced, but intellectual property cannot. So that's why it's so important to really protect our intellectual property, because once it's gone, it's just gone, right? So if we lose our car, God forbid, we can go buy another one. But if we have an idea and we don't protect it, once it's gone, it's gone. So really want to be careful with that. So what are the benefits of owning your own brand? And we'll go over three main benefits: identity, integrity, and impact. So first, identity. Each of us has a unique footprint on the world, and so does our business. So my law firm is not the same as Johnny Cochran's law firm, right? We're both doing law, but we each have our own identities. Well, he had his own identity. So our product was different. So that's the same thing for everybody. You know, even if we're doing something similar to what someone else is doing, because it's us doing it, it's going to be different. So our identity is communicated through our brand. And so we just have to keep that in mind. So that's why we have to be very contemplative when we're considering our brand. What colors do we want to use? What typography do we want to use? I've recently been considering redoing my brand, you know, because my colors mean a certain thing, the typography means a certain thing, and I want to make sure what I stand for is being communicated through those things. So these are really topics that we should be contemplative about and not rush into them. When we know our identity and we value it, we can protect ourselves and generate another stream of income. So brand ownership not only solidifies who we are, but it can also become another stream of income. For instance, if you are franchising your name like McDonald's. So the owner of McDonald's does not have to own a million McDonald's, right? But because they own the McDonald's name, they can license it to people who want to use that name to generate business. So brand ownership and identity can become another stream of income if you position yourself correctly. Integrity. So in terms of branding, integrity means our clients get the same experience with us each time or better. So think about Walmart versus Target, right? So Walmart, you know what you're going to get, right? But you're okay with that because of the prices. Whereas at Target, you have a certain standard, right? You want a certain treatment when you go to Target, and you've come to expect that. So we would rather pay more, some of us, we would rather pay more for that extra client experience than what we would get at Walmart. And that's integrity. I expect when I go to Target that, oh, somebody's entering. I expect when I go to Target that they will treat me a certain way, that I'm not going to have to do self-checkout, that if I need to ask a question to someone, somebody's going to be there to answer my question. When I go in Walmart, half the time I ask a question, the person says, I don't know. And I'd be shocked every time, like, y'all can really get that answer? They're like, I don't know, and walk away. So we don't expect that from Target, right? So our brand integrity allows our clients to have a consistent experience with us. Hey, Cache, we just got started. Okay, impact. So just like this little drop of water is having this huge impact on this stream, right, on this pond, our business can and will do the same thing if we are monitoring our impact and really taking that into mind when we're going about forming our businesses and building our brands. So we should be impact focused. If we are impact focused, that takes us from a mind frame of hustling to a mind frame of how do I want my grandchildren to live? So let me plan my business and build my brand based on how I want my grandchildren to live. That's a different frame of thinking. Okay, so moving on to the types of intellectual property protection. So there are 5 main ways, and hopefully somebody will allow me to get through them. I know you guys know because you have kids, but he was quiet before I got started. Okay, so types of intellectual property protection. So we always want to start with the contract. And Brian knows this. He took my contracts course. We also just recently completed an NDA for him. So we want to have our contract in place. So our contracts are going to protect us when we're just having a conversation. Before we even get to the table, before we even have a product in our hand, we have a contract with someone. So in addition to an NDA, you also want to consider a contractor contract. So in terms of protecting your intellectual property, a work made for hire is going to be the best type of contract to have. And I think Brian and I think we talked about this as well. So a work made for hire contract basically says, hey, contractor, when you create something for me, even though you're creating it, it belongs to me. Naturally, the law favors the person who created the work. So for instance, if I am hiring someone to draw my logo, the law favors that person who actually draws the logo because they are the creator. Think about the US, think about our history. We're very much, we appreciate ideas. We want to encourage people to generate ideas and to be entrepreneurial. So we give deference to creators. So, well, sometimes, right? If they're a certain hue, we give deference to the creators. But just think about that. So if I hire somebody to create my logo, the law is naturally on that person's side in terms of ownership. However, if I give that person a work made for hire contract and I say, hey, I'm hiring you to create this, but once you make it, it belongs to me. That person actually signs over any and all rights they have legally to that end product. So that's another way to protect your intellectual property. Some people are like using Canva, for instance, using Canva and other like free images on Google to create logos to be a part of their brand. And you're not able to really protect those things because you can't own them. Somebody else owns them. So just keep that in mind. Whenever possible, you want to have a work made for hire contract. This also comes into mind when we have our contracts for photographs. And I'm not one that's like super picky yet. You know, probably in the future, God keeps blessing my business and I'll get more selective in terms of who I let photograph me. But that's the real thing too. When a photographer takes your picture, the photographer actually owns the picture, even though you're in it. So you would need a work made for hire contract to actually own those photographs. And so Brian, when you posed that question to me last week about how you can protect your business, if you have your children in your photographs, you have your wife in your photographs, then you don't have to worry about anybody claiming publicity rights. If you're taking the photos yourself, then you don't have to worry about anybody saying, hey, this photo belongs to me. So just starting out, I usually recommend, hey, take your own photos, have your family in the photos. As you build, then hire a photographer, perhaps even hire models. But just starting out, I would just use my family and I would take photos myself. You can take photos with iPhones and Androids. So that's a great way to start. Okay, so moving on. Did anybody have any questions about that? I want to make sure I give space for that. Okay, so,
No,
okay, good. So moving right along. Our copyrights protect creative works in a tangible medium. And I have a slide on each one, so we'll go over it. So think about, you have an idea, you make a creation and you actually put it down into something tangible. You instantly have copyright protection. So all those pictures that our babies like to draw for us, right? They have a copyright interest in those photos. They took the time, they thought about it, they wrote it down, they put it in a piece of paper. That's copyrighted. Songs. So people who write songs, they have, notes on the page. Once they write that down, it's copyrighted. Now, if you have a song in your head and you never write it down, it's not copyrighted. So that kind of comes back to reading music, knowing how to read music, knowing how to write music is very important because that will allow a musician to own more of what they're creating. But you have a lot of artists who they don't know the note. They know how to say it in their head, or they know the vibrato they want, but they don't know how to write it. So somebody else has to write it. Well, then that's their copyright. So that's just a sidebar. But that's what a copyright is. Whenever you have something that you're creating and you put it into a tangible form, then it's copyrighted. If you take a photograph, again, now a lot of photographs are digital now, but you're able to print it out. So that's a tangible medium. There's copyright protection there. A trademark protects a brand name, a slogan, and also a logo. So again, we'll go through what each of those are, but a brand name like Target, that's a brand name. Slogan, that was easy, right? I think that's Office Depot, that's a slogan. A logo, you guys are familiar with logos. So those would be protected by a trademark. Then you have a patent. A patent protects scientific inventions. So for instance, I have a client who are designing, they are designing a dating app. So they have a patent right now to protect the, it's not a swipe technology, but the technology that they use for like the matchmaking. They have a patent for that. So if we have any kind of like scientific inventions, you want to have a patent. And then a design patent protects the way something looks. So like Coke, for instance, Coke is always going to have that red background with the white writing, the certain calligraphy on the writing. They have a design patent for that. So we can also have that for our products as well. Okay, so copyrights. Now it's important to remember that we cannot copyright an idea, only the way it is expressed. So we look at this this picture, we have 3 smiley faces, right? We can't copyright the idea of a smiley face, but the way it is expressed, we drew one as a happy face, we drew one as a blank stare, one as a sad face. The way we express that and actually putting it in a tangible form, we're able to protect that. Come on, baby. Thank you. Otis is taking them. But we're not able to protect the idea of a smiley face itself, only the way it's expressed. Copyright protection. This is what's interesting about copyright protection, which I really like. And it goes back to the idea I said earlier that as a country, we favor creation and we favor creators. Copyright protection happens as soon as expression is put into a tangible medium. So as soon as I write the song and I write the notes out, I have protection. As soon as your baby girl, baby boy draws that picture for you on paper, they have protection. You don't have to actually register that. You already have a protection. Now the registration comes in when you want to have the right to sue somebody for infringement. So it's not enough sometimes. It's not enough just to have the protection, but you want to be able to also challenge someone if they're using your copyright. But like the example for our kids' photos now, unless they're like the next Picasso, which they may be, but if they're like the next Picasso, then yeah, I'm gonna go ahead and register that picture so that no one can infringe upon it. But if they're not the next Picasso and, you know, they're saying it's a tree, but it looks like, you know, a circle, then I'm probably not going to register that. They already have that copyright protection. I'm not really concerned with somebody infringing on that. So just keep that in mind. You know, everything that you write, you already have that copyright protection. So I see people sometimes trying to copyright everything. And it's like, you really don't need to, only if you're concerned with infringement. Same thing with books. Books will be copyrighted. So you want to copyright it, you want to definitely register that, right? Especially if you're going to put it on the market, if you are marketing your books or your plays to agencies or different production companies, you definitely want to have a copyright registration so that they can't then steal your idea and steal your work. Well, can't copyright ideas, but they can't actually steal your work. So that becomes very important. One thing people don't think about copywriting is curriculum. And I see a lot of people right now like teaching, coaching, the curriculum that people actually develop, that's copyrightable. Brian, I know that you may have drawings like of your clothing and items that you're going to come out with. Those things you will want to go ahead and register for copyright as well, because you don't want those to be infringed upon. To register our copyrights, we want to go to copyright.gov, and it's $45 per application. So, I mean, I think it's the most reasonable one in terms of intellectual property protection, but it can just also, you can have so much you want to copyright, right? So you might have songs, books, curriculum, certain designs, you know, that can be a lot. So it's not a high price point, but you may have a lot of things that you want to copyright. Say, for instance, if you are a songwriter, who knows how many songs, you know, some people write poems. It's not enough just to copyright the book. You need to copyright each poem. So, you know, I think the price point is comparable to how much you actually may be using the service. Any question about the copyrights?
Yeah, I got a quick question.
Okay, go ahead.
So in my situation, I got was it 6 images in like 3 different hues? So it would be like it's the exact same. Well, it's the same 6 pictures, but just in different colors. Would I have to copyright all 18, or is it more of a just take care of the original 6 images and color doesn't matter?
That's a good question. And I'm leaning towards just the 6 images, but let me do some research and get back to you. Trademark tends to include color, like in terms of like branding and slogan and logos, the color is important, but copyright is typically just the work itself and not necessarily what color it's in. So think about, if I write a song and I write the notes out, I might write it in black ink, I might write it in blue ink, those notes in that order is what's protected. So you're actually protecting, the shape and the style of the clothing and not the color. So that's my first response, but I'll definitely do some research and get back to you and let you know.
Okay, thank you.
Sure. Any other questions about that? Okay. And hello, Firstborn. I'm not sure who that is, but we jumped in. So if you have any questions, definitely just let us know. Oh, that was not supposed to happen. I know Canva not playing with my Canva done played. Oh, it's out of order. I'm about to say Canva don't play. Okay, so trademarks. This is our next big category of classification. So trademarks can be tricky, right? Because a lot of people want trademarks. A lot of people should have trademarks, but there are a lot of things that cannot actually be trademarked. So you cannot trademark an idea. So school, right? A school is an idea. I cannot actually trademark the idea of a school, but I can trademark the name of my school, right? So with trademarks really get to identity and not the thing itself. So you cannot trademark vernacular or phrases that have become part of our general terminology. So like, ain't nobody got time for that. The Black lady who blew up and it was so funny. She was talking about bronchitis. She later tried to trademark that, but she was not able to because they had become part of our vernacular. So that's unfortunate, right? Because maybe she might have missed out on a payday, but people were able to make T-shirts and things like that with that phrase on it because the PTO office, the trademark office had determined that had become part of our vernacular. Same thing with Google. Google used to have a trademark, but they lost it because now Googling something is a verb. To go Google something, you might not even go to Google the website. You might go to Yahoo and Google, right? But it's the verb. Or you might be being funny. Go Google it. Go Google me. You're not actually going to the Google website. So they lost their trademark. You also cannot trademark a name that's not being used in commerce. So for instance, Cache Butler. If you just want to trademark your name just because, hey, I think it's a cool name, I want to trademark my name, that would not be accepted by the trademark office. Now, if you are using your name to sell something, that means you're using it in commerce. Think about Beyonce, right? She has CDs named Beyonce. I don't think she has clothing named Beyonce, but she sells like tickets and stuff with just the name Beyonce. Everything is just Beyonce. She's using that name in commerce, so she's able to trademark that name. Same thing with Blue. I think they trademarked Blue Ivy. Well, they have been using her name in commerce like since she was born, and now they have the Ivy brand. So they were able to trademark that. The more arbitrary, the better. Think about a company named Apple selling computers. So when I think about an Apple, I don't think about computers at all, right? So, well, now I do because it's a brand. But before that, we didn't put apples and computers together. That means that the name is totally arbitrary versus being descriptive. So if I have a computer company and I'm calling it computer company, that trademark is not going to be registered because it's descriptive. It's describing what the store is or describing what I'm doing instead of actually being a name that I'm assigning to it. So again, it comes back to identity. How are you identifying the thing versus what are you doing? Those are two different things. Any questions about that?
Nope.
Okay. So trademarks protect business names, logos, and slogans. So think about Nike, right? So Nike, the name, that's a trademark. The swoosh itself, that's a logo. That's another trademark. And then Nike with the swoosh is a trademark. Those are three different trademarks. And then of course the slogan is just do it. That's a slogan. So Nike, there's no telling what their intellectual property is worth. I mean, because we just went over 4 trademarks that quickly. So yeah, but that helps you to break down like what the differences are. So unlike copyright, you do not, so this is kind of a yes and no question. What I want to say is unlike copyright, you don't have protection as soon as you start using a trademark, which is true, but you do have some protection under common law. So you don't have protection as far as like you actually have it registered with the government, but you have what's called common law usage. Common law usage. The thing with common law usage, which is just using it without registering it, is that somebody can come behind you and actually register it and take your name. So common law usage is the measure of protection. If there is a discrepancy or a disagreement between somebody who has common law usage and somebody who actually registered, the person with common usage will get some credence, especially if they've been using that name for some time, but it's just not as firm as actually having the trademark itself. Unlike copyright, whenever you write it down, it's automatically protected, that's yours. And that makes sense, right? Because if I draw something, that's my picture, but a name, Apple, somebody could have been using Apple to sell computers, in well, they're in California. They could have been doing that in New York, but I just had no idea. That's different than actually creating something yourself. So that's why in trademark law, you don't have like that same automatic protection, but you do have a measure of protection if you've been using it in commerce and you've been using it for some time. But it's just better just to go ahead and get it registered. And then, of course, it gives you the ability to enforce your trademark when you actually register it. An important thing to keep in mind is that trademark protection only protects against brand confusion. So that's why we have companies like we have Delta, it's not airplane. What do you call it? Delta, I know it's not called a airline. Airline, that's the name. Thank you. You have Delta, the airline, but then you have Delta, the company that sells parts, right? Both are using the name Delta, but they're in 2 different categories. So that doesn't cause any brand confusion. When I show up at Atlanta Airport, I'm not looking for Delta, the tools, right? I'm looking for Delta, the airline. If I go to Home Depot, I'm looking for Delta, the tools. I'm not looking for the airline. So there's no brand confusion. So that's an important thing to note because a lot of times people will, they think they will register their trademark and they own that name. Like, this is my name now. But yeah, that's your name for that category. But that name can be used in other ways. Remember, the US favors creativity. It favors being an entrepreneur and generating things ourselves. So we want to make, when I say we, I talk about us as a nation, we want to make ideas and commerce, we want to make them go together smoothly. We don't want brand confusion, but we want to make things like liquid and easily accessible. So if someone is truly not causing brand confusion, even if they're using your name, then it's likely not going to be a trademark issue. It's not going to be an infringement issue. Now, another thing to keep in mind is a lot of time people will register under one category, right? Because that's the cheapest, and we'll get to that. So trademarks are pricier. It's $250 per application, but that only gets you one category. So say for instance, like I'll go back to my clients who have a dating app. They're using that name for the dating app. So they have a trademark in that category, but they also are starting to make clothing using the same name from the dating app. And they're also starting to have events using the same name from the dating app, but they only have the name registered as a dating service. So they will actually have to go back and complete more applications and pay another application fee for the clothing category and for the event category. So that's the important thing to keep in mind. So you may have one idea when you first get your brand name protected, but you may expand into other fields. And if you do, you have to register in each of those fields. Sometimes we come up into a situation where, you know, our name might work for one field, but it might not work in education because somebody may already be using that name. So that's just something to keep in mind. You know, if you have a great name, you have a great brand, and you already know, listen, I want to do apparel, I want to do events, I want to do education, just go ahead and make the sacrifice and make the investment and register them all at the same time. Because if we piecemeal it, we can run into someone actually taking that name in another category. So that's just something to keep in mind. And with the copyright, a copyright is relatively easy to register on copyright.gov. A trademark is more difficult. So I usually recommend hiring an attorney for a trademark, not necessarily for copyright. I think that's I'm not gonna say very easy to do, but it's easier to do. A lot of times with a trademark, especially if your name is popular, you may get something which is called a trademark action, an office action. And that's when the trademark office has sat down and say, hey, it might be these various issues with your trademark. And so then you have to then provide legal arguments as to why those things really aren't issues. So for that reason, it's best to have an attorney. Remember, a copyright is something you already created yourself. So there is no other person that you're trying to compete against, no other category. So it's a lot more cut and dry. Now, if your name is super arbitrary, for instance, if you are selling tennis shoes, but the name of your company is Lemons, you're probably fine. You're a company named Lemons selling tennis shoes. That's totally arbitrary. You probably wouldn't get any office actions, and you can go ahead and probably just register that yourself. But anything else that's not like totally arbitrary, I would recommend legal counsel for that. Any questions about the trademarks?
I have a question about like what you said in the beginning. So you can trademark something and it becomes so popular that you lose your trademark because society changed the meaning of it?
Yes, you can. So you actually have to recertify your trademark every 5 years. So it's yours, you know, once you have it, it's yours, but every 5 years you have to recertify it. So the trademark office would do like another review. And yeah, so at that time it's possible to lose it. And it's not necessarily that society has decided that it means something else. It's like society has stolen it in a sense, it's taken it as its own. So that's what happens sometimes. It's not often. The same thing happened with Xerox. Like, oh, go Xerox it. Well, no, that's the actual company name, you know, so they lost their trademark as well.
Wow.
Yeah, that's a good question. Any other questions about this? Okay. I'm going to go back really briefly because I know a couple people missed the, can I go back, please? I'm going to show you guys the types of the ways to protect, just in case you weren't here from the beginning. So you always want to start off with a contract. We talked about NDA, which is a non-disclosure agreement. So if you're in a conversation with somebody, you think you're going to do some work with them, you want to make sure you send them an NDA first to protect your idea. We also talked about, I'm glad I came back to this because we didn't talk about the non-compete agreement. You also, if you're hiring a contractor, you want to give them a work for hire contract. That means regardless of what you create for me under this contract, the final product belongs to me. And this is something really important to have when you're hiring a photographer or hiring somebody to like design your logo or design your patent. You might have an idea, but you just don't know how to put it on paper. So you're hiring somebody to do that. You want to make sure you have a work for hire agreement. And then a non-compete agreement is usually just a clause. So a non-compete clause that's in your contract basically says, hey, for the term of a year, you agree not to work with businesses similar to mine in this same capacity. So for instance, my clients who have the dating app, they're working with somebody who is doing their marketing. Well, they don't want him to turn around and start working with another dating company in 2 months. You know what I mean? So that's why we have our non-compete agreements. If it's a contractor, usually you can only get away legally with a year-long agreement, non-compete clause. But if it's an employee, I've seen like 2-3 years, the law will let you slide with that. But I just wanted to go back to that. And then I had some questions in here. Oh, here's a test. Okay, so we're going to be interactive with this. So just do it. Tell me how you would protect it. Well, tell me what it is. Tell me what vehicle would protect this. Just do it. And let me grab the baby because he's just gonna keep crying. 1 second. Daddy had to go back to work. Okay, so who's gonna be brave? Just do it. How are we gonna protect that?
Trademark.
No brave. Trademark. There you go. It's the slogan. Okay, we did that one. Okay, Paris Hilton. That's someone's name. How would you protect it, and do you think it would go through for registration?
I think that would be a trademark if she's using it for an actual product or service or something, then it would go through. But if she's just trying to trademark herself as a person, then it wouldn't get approved.
Perfect. That's absolutely right. And I know she does use her name for different things, so she probably already has a trademark. Okay, what about grandma's cookie recipe? You're going through some old boxes. You see grandma's cookie recipe in the bottom of the box. Can you protect it? And remember, we went over other ones besides trademarks and copyrights. So you might want to think back to that as well. Okay, so this one cannot be protected. Recipes cannot be protected under intellectual property law. What can be protected are formulas. So like the Coca-Cola recipe is actually a formula that's protected by trade secret. It can also be protected by a patent. So a formula is protected or can be protected if you register it. Same thing with like certain type of hair care products. Those things can and should be protected. Grandma's cookie recipe is not protected. It cannot be registered. It's a recipe, not a formula. Okay, what about Get It Poppin'? as a slogan. Is that registerable?
No.
Good. No. Because we say that in vernacular, we say get it poppin'. Now, Brian and I have a friend who owns a company. It's called Get It Poppin', but she does balloon decor. It's not her slogan. So as a slogan, it probably wouldn't get registered, but as a company name, it can get registered. You guys see that distinction?
Yep.
Okay. Okay, what about the next one? A song, Isn't She Lovely?
The
Copyright.
title of the song?
Title of the song, yeah. Or the song itself. Yeah, it would be copyright. Because remember, the moment you write it down, it becomes a creative work that you're protecting. So I don't really see the name. I don't really see the point of writing down the title without the music. You know, I don't. That's actually a good question. If you just write the title without the music, I would say that's probably not a creative work. So I would say no, you couldn't copyright it. So it would have to be the title with the actual music notes. Unless you like wrote out "Isn't She Lovely" in a way that made it like a picture or like a drawing. Like maybe you wrote the letters in such a way, like fanciful. But if it's nothing like that, you just wrote "Isn't she lovely?" I don't think so. Okay, and what about my name, Kianna Chennault? Can I protect that?
Yes, because you use it for business, right?
Okay, so this was really a tricky question. So I don't really use my name Kianna Chennault as much as I use the last name Chennault. So I think I probably could trademark Chennault if I wanted to, but probably not Kianna. Probably not Kianna Chennault. Okay, so that was the test. And I know we had like 3 other ones, but we're at time. So we might have to do a part 2. We didn't go over patents. We didn't go over trade dress as much. I told you guys what it was. And we didn't go over the formulas. So if you guys are interested in that, we can have a part 2, but I've had conversations with most of you guys already, and I knew that copyright and trademarks were the ones that we were going to focus on. But, you know, if there's some interest, we'll definitely do a part 2. Any wrap-up questions?
I have a question about the grandma's cookie recipe.
Sure.
What makes a recipe different from a formula for you to not be able to trademark a very particular recipe? Like I know some in this specific instance with it being cookies, the standard recipe is very standard across the board, but it might be the specific measurements that makes it different or the cooking method that makes it different. So what would how do I phrase this question? What would need to be in the recipe for it to no longer be considered a recipe, but a formula?
Yes, that's actually a good question. So the thing with a recipe is, so first you want to have those set measurements, right? Which I know some recipes do have, but then you also can make a cookie without necessarily following that recipe, right? So if grandma's cookie recipe says 3 sticks of butter, but I use 2.5, I'm still gonna have cookies, right? And so it's just not that distinctiveness there. Whereas think about like a hair product and how certain things like oils, they come together and they make different chemical bonds. If you don't have that exact measurement, you're not getting that bond. It's not going to be the same consistency. It's not going to do the same thing that it's marketing to do. And so that's the difference. Now, if it's beyond a cookie, but you're saying, like, say for instance, it's a weight loss cookie, right? So this particular recipe is actually doing something, then that's different. You can probably patent that recipe, because at that point, it's not just a cookie, it's actually those ingredients are coming together to have a certain function. You see what I'm saying?
Yeah,
So
that makes sense.
yeah, it's more so like the ingredients coming together having a function is what makes it a formula. And without those precise measurements, you're not going to get that function. But
Right.
if it's just a recipe, it's just like you're going to have it either way. It just might not taste as good.
Okay, so the recipe is more of a loose guideline and the formula is very to the T to get a specific result.
Yes.
Okay.
Yes.
Thank you.
Sure. Any other questions? No? Okay, well, thank you so much, guys, for joining me. This was fun. We'll make sure that everybody gets the replay. Hopefully, you won't hear too much crying in it, and you'll be able to hear. But if you have any questions, definitely let me know, and I'll be happy to assist. But
All right, thank you.
sure. Look forward to seeing what you guys create.